Katie, can you hear me?
I can. Go ahead.
Okay, can we go ahead and start? I don't see my own picture. Good evening. I'm Jeffrey Coe. I'm an orthopedic spine surgeon, Ortho NorCal in Northern California. I'm the co-chair of the Lumbar Spine Research Society Educational Committee, and we're putting on this program today in conjunction with Michael Lee, my co-chair from the University of Chicago. This is the second session on linking the law and the lumbar spine. Perspectives, pearls, and pitfalls, lessons learned and change in practice. My role today will be the moderator to introduce the speaker, and Mike Lee will have a directed and I'm sure very lively discussion after the speakers have concluded their program. The first speaker who was scheduled to speak today, this was Chris Stonebaugh, unfortunately had a personal emergency, and his talk will be deferred a week, and he'll be in the slot that I was scheduled to speak in early next week. So stay tuned for the plaintiff's attorney perspective, which I'm sure will be very, very exciting. We look forward to his talk. Next slide, Katie. The instructional course is certified for 4 Category 1 CME credits. Visit the LSRS website for information on how to claim your CME. Our first speaker, let me just introduce all of our speakers and who they are. Our first speaker will be Peter Brandt. He's a partner at LivingstonBarger. He'll be speaking on the defense attorney perspective. Our next speaker will be Jim Harrop, professor of neurosurgery at Thomas Jefferson University, the surgeon's perspective, part 1. And then we have Alex Vaccaro, the surgeon's perspective, part 2, who everybody knows. He's chairman of the Department of Orthopaedics, professor of neurosurgery, president of Rothman Institute, and 16 million other titles to his name. And he'll wind up the session with the surgeon's perspective, part 2. So let me go ahead and introduce Peter Brandt from LivingstonBarger. He will go ahead and give his talk on the defense attorney's perspective. Peter?
All right, thank you very much. Thank you for asking me to be a part of this. Here we go. Thank you, Michael, for just pulling up my PowerPoint. And thank you, Michael, for inviting me to be a part of this. Hang on just a second. And I will get it going, hopefully.
Do you have your slides on your own computer up yet?
I'm trying to get them up at this point, and I will here in just a second.
Looks like you're on Safari, Peter.
Pardon?
Looks like you're on the Safari application.
Okay.
If you click the bottom screen, you should be able to, there you, okay. I think I saw your slides in the background.
Yeah. Try one more time. Here we go. There we go.
There you go.
Okay. There we go. And I think we are.
If you hit the top left-hand corner, Peter, where it says Use Slideshow, try clicking that button. That might give us the
There we go.
presentation.
Thank you. Sorry. All right. So what I'm going to talk about, or what I was asked to talk about, is an experience that I've had. I'm representing a number of spine surgeons. I currently have about 13 cases pending for spine surgeons throughout the state of Illinois. And so I talked to Michael about it, and the thing that I thought was most profound about what I was seeing was not so much that the surgical care was inappropriate or wasn't going the way it was supposed to, but it really dealt with patient expectations. And so I wanted to talk a little bit about that because I think it's a great way to avoid a problem that's actually pretty easily accomplished that has really nothing to do with surgical care. So the informed consent issue really has to do, and the cases I'm going to talk about really have to do with faults in discussion, faults with communication. So surgeons can have great skills, and great technical skills, but have difficulty in communicating with patients in a way that brings expectations to where they should be. So I have a couple cases where the first one is a discussion, or I want to talk about what is essentially poor documentation. And this is what I see in most of the cases that I looked at, and most of the cases I'm defending. So this statement is a very brief 5-line informed consent statement that actually appears in the operative note. It doesn't appear in the clinical note, but it has basically your standard, we've discussed the risk, patient understands. The discussion or the indication in this note is that some of the perioperative medical risks were discussed: nerve root injury, pseudoarthrosis, those types of things were discussed. The problem with this is that, of course, it doesn't document that there was a thorough conversation with the patient about patient expectations. And so this is one of my clients that, although the surgery he performed did well, it was a hemilaminectomy, decompression, transforaminal interbody fusion, L4-5. It was an allograft. He did use BMP. Surgery actually went fine, but the patient who had had prior surgery was very unhappy with the results. And we're going to be in litigation for probably 3 or 4 years over this thing. I think it's completely defensible. It's just that the informed consent just wasn't happening here. So I'm going to show you one. I have a case now that just got dismissed. It was recently filed. And what I'm showing you now is the progress note from this particular surgeon. And what he did is what I think is a good example of good documentation. It's not in the operative note. It's actually in the preoperative clinic note a couple days before surgery. And what he did, which I think is helpful and what ultimately brought about the dismissal, was this. He broke it out and he indicated first that he had interpreted the studies independently, and then he went over those studies with his patient. He then documented that he had a conversation about conservative approach, which would be physical therapy, aerobic exercises, other things of that nature, a TENS unit, pharmacological treatment. He charts also that in some of the invasive approaches, such as steroid injections, were also discussed. And then the surgical options were also discussed with the patient. And then at the bottom, he goes through and he basically picks through the various options, and he talks about the fact that some have risks, some have more risk than others. The risk of proceeding with surgery, for instance, could result in some problems for the patient, some loss of stability, and the fact that the patient may need a fusion in the future. And so he then documents at the end that after all this discussion, the patient decided to go forward. When I talked to my client after he had been sued, he actually remembered this patient. And he said to her before surgery that he didn't really know that surgery was going to help her. And he asked her, I don't know that surgery is actually going to help you. Do you still want to proceed? The surgery he did perform had no problems with it. She actually did do better, but she didn't have what she considered to be an appropriate, I guess, response to surgery. And so suit was filed, but in Illinois, you have to have your suit pre-certified. And so that means that either before suit or within 90 days after suit, you have to get a certification from a care provider who says they've read the records and they find merit to proceeding. In this case, the case was dismissed because they couldn't find a surgeon to review who had reviewed the medical records to find fault with the outcome, because this surgeon had appropriately laid out all the options, had laid out all the pluses and minuses, all the adverse outcomes, had a thorough discussion, a thoughtful discussion with the patient. And as a result, the case got dismissed right away. And there's really no difference between these two cases except this documentation. When he prepared the operative note, he also included a statement, much like the one we looked at a moment ago, that he went over the procedures, that he discussed the risks of hardware failure, pseudoarthrosis, infection, bleeding, all those other things. And this in and of itself would not be sufficient, I think, to have avoided suit. But it did relate back to what he had put in his clinical note. So it did bootstrap the two together, and I think was also helpful in getting the case dismissed. This is just the note. So when I was doing some research for my portion of the talk tonight, I found that there had been some research done by the British Association of Spine Surgeons. And what they had found was similar to what is true in our country, and that is about 30% of patients who have had spine surgery are unhappy with the surgical results, regardless. And that's a higher percentage than what we see in other surgical interventions that are in cases that certainly I have across my desk. Again, most of these did not involve hardware problems or technical problems with the surgery. They really had to do with a failure of communication and a failure to really discuss the reasonable expectations of the patient with the patient. And so this checklist I thought was very helpful, and it's consistent with what I have been talking about. So a description of the pathology requiring treatment, that's what the doctor did in the last slide I just showed. And what he did was he looked at the pathology as seen on imaging and he discussed it with the patient. There's then a recommendation of a procedure, what, if it's going to be anterior, posterior, and discussion with the patient about that. A natural history of the condition if left untreated. So I get sometimes I get a pushback from surgeons when I talk about this, and they say, yeah, if we give them too much information, they may decide to forego what is essentially needed treatment or treatment that can help them. I think you have to include a natural history, what's going to happen if you don't have treatment. The benefits of surgery, pretty obvious. The alternatives to surgery, also, I think, pretty obvious. Is any treatment needed before surgery, such as physiotherapy? It's important to lay out what's going to happen before surgery, and that's probably done fairly well, but also what's going to happen afterwards. The next bullet point seemed to me to be the most important. Has the patient been asked what his or her expectations are of the treatment? So I think if you sit down and you have a conversation with the patient and you say, what do you really expect out of this? This is consistent or goes along with what I just said in the second case we looked at. The surgeon asked the patient or told the patient, I don't know that I can make you better. But if you have this conversation with the patient and you, most importantly, document it, and then you document that you told the patient that her expectations may not be met, you've saved yourself probably from being sued. The next bullet point is, has a specific surgery been proposed? That's pretty straightforward. Are there guidelines and websites? The British group really pushes the idea of videos. If I'm at home and I'm going to go put together something, I'm probably not, that I've ordered, I'm probably not going to look at the instructions. I'm going to go to a YouTube video and I'm going to learn how to do it in that fashion. And I think it's a common way for patients to get an idea of what the surgery entails, but also to share with them the outcomes in a kind of objective standpoint, or from an objective standpoint, and reiterates what you've told them in this process. If they want a second opinion, obviously you want to set that up. You want to importantly talk about any complex postoperative management. Are they going to have a halo? Are they going to have long-term physical therapy? Could they have drop foot? Any of the things that you see in patients who are pretty complex going in, and you know they're going to be pretty complex coming out. And finally, is there anything specific that this patient requires? So this is pretty thoughtful. The important part is to document it. Documentation is going to save you, because the only thing that the physicians look at if they're reviewing a case for a plaintiff's attorney is what's in the record. So what you may remember or what you may say on deposition is not going to make a difference going in terms of making a decision if you're a plaintiff's attorney about whether to file suit or not. I think that the art really here that has to be cultivated, and hopefully can be part of what we're talking about here and can be cultivated by the surgeons, is really an art of conversation. So it's really about conversing with the patient and having a decent conversation, and so that they feel comfortable they can share those things with you, and then making sure that you document it. And so documentation on informed consent should be much longer than what I typically see, and probably much longer than most surgeons are doing. I tell my clients to write like Faulkner and not like Hemingway. You want to have a long paragraph in there about what you've discussed. And I think this will help you. It helps stop lawsuits before they're even filed. The other thing I wanted to share with you, assuming I've got time, is testimony. So the most important thing for me in defending physicians in medical negligence cases is the deposition of my client. If my client does well on deposition, the rest of the case will go smoothly for us. If they do poorly, we can only be climbing uphill the rest of the time. And so the plaintiff's attorneys know this. They know if they can get the defendant to concede that there was a breach in the standard of care, or there was something substandard about what happened, it doesn't matter how good their expert is. Their expert can be subpar, so to speak, and it won't make a difference, because they've already gotten the defendant to concede things. And so what we've done, and I don't know that all defense firms have, but we certainly have spent years working with trial psychologists to do better by our clients, to do a better job of informing them about how to avoid the pitfalls of discovery deposition answers. And so we ask that our clients listen to us. We often get this type of response. I would say to you that depending upon the physician that I have, I can spend sometimes 8 to 10 hours over a couple of days getting them ready just for their deposition. It's important that they do well, and it sometimes takes a lot longer, but the system that we have cultivated, and the one I'm going to talk about here, works. We found that we've gotten cases dismissed after our client's deposition if we basically go through this process with them. So the most important thing I'm going to say about this is what's on the screen now. And if you don't remember anything else I say about this, this is the most important. What we found is that if our clients wait 3 to 5 seconds between question and answer, and so that's not normal speak, that's not speaking in a normal rhythm. If you take 3 to 5 seconds, though, it has the effect of giving your brain time to think and time to provide a thoughtful, discrete answer to the questions. And so this is important for a couple reasons, but the most important reason is, in a deposition, my client is nervous. Anybody giving a deposition is likely going to be nervous. But if you can break up that nervousness by slowing things down between question and answer, but also giving your brain time to think about the questions, this will go a lot better. The answers will be a lot more cogent and more focused on the question that's being asked. And so ultimately, this gives my clients control, and it puts control in the hands of the deponent or the witness as opposed to the plaintiff's lawyer. Most of the depositions I sit through, and I sit through them virtually every day if I'm not in trial, most of the depositions will contain general medical questions. The plaintiff's lawyers don't really care about the specifics of the case. They already know what the specifics are, or at least they have their own version of the facts. But what they're going to focus in on is the general medical questions. And these are general platitudes about what should happen in spine surgery. And so these are questions that typically begin with the word agree, such as, do you agree that BMP is an off-label product that should not be used in spine surgery? These are general blanket statements. And these are statements that if you say yes to, you are cooked. You are in a bad situation right off the bat, because these are questions that are not geared to help the defense. These are questions that are geared to help the plaintiff in the plaintiff's case. They really don't care what your opinions are in terms of the actual specific medical questions. So a lot of times the facts of the case may not even be barely touched upon. A lot of time is spent with these general medical questions. So how do you answer these? Both being truthful, since you're under oath, but also honest to yourself. And so I'm going to move forward here a little bit because I know I've got a little bit of time, but what we talk about is that yes is rarely a good answer to these questions. These are questions that the answers really ought to be no, sometimes, maybe, not always, depends, not necessarily. And the reason is that these questions are put forth with the proposition that medicine is an exact science. And the fact of the matter is that they take judgment out of the equation. And so when you answer these general medical questions and you're given time to think about it, and you think about exactly what's being asked of you, the answer really is most of the time that these general medical platitudes are sometimes applicable, but not always. In law, the plaintiff has to prove their case by probabilities. In other words, they have to show it's more probably true than not that there was substandard care. The words possibly, sometimes, maybe, not always, not necessarily, depends, don't get them there. It doesn't get them where they want to go. And so these are important answers to those types of questions. If you get the follow-up question, if they're silly enough to ask you, well, you said that it depends, what does it depend upon? And the best follow-up answer I can give you is that every patient is different and that this is not an exact science. And as you can see with these answers, we've really not imparted any information. We really haven't given the plaintiff anything to chew on that's going to be used at trial as a hammer against the witness or the defendant in the case. I had a doctor the other day say this. He was being pushed by a plaintiff's attorney on these types of general medical questions. And he finally just said, that's not how medicine works. You don't understand how this works. And what he was saying is that this is gray. It isn't black and white. The plaintiff's attorneys really want things black and white. And if you play that game, if you play the game correctly, and it is a chess game, you've got to make it clear that there are no black and white answers to spine surgery or really any other type of medicine. If I've got a few more minutes, I'll just talk about the other things that we tell our clients.
You have time. Keep going.
Okay. Before we get to the deposition, You probably have heard about this, but if you've not, the reptile theory is one that was promulgated by the plaintiff's bar 5 years ago. It's still used a little bit today. And so the reptile theory in the shortened version is this. The plaintiff's attorney will, instead of using standard of care as the basis for conduct, will talk about whether or not the care provided was safe. And so this revolves around the term safe or safety. And so the questions come out this way. Was it safe to discharge Mr. Smith from the hospital knowing he still had a elevated white count and was in pain? The problem is with that, and the problem with any safe question is twofold. One is doctors are trained to talk about safety. There are safety committees at the hospital. There are safety protocols, and safety is all over the place in the documentation at the hospital. But the standard of care doesn't require a physician to act safely, because the problem with it is safety is never defined. It's never defined in the context of a discovery deposition. And so the plaintiff's bar loves this because physicians choke on it. They'll choke on the idea that they're going to say, no, it's not my obligation to keep the patient safe, because you haven't defined what safety means. Two types of questions that are a favorite of the plaintiff's bar on depositions of my client and my experts are the rule out question and the differential diagnosis question. So the rule out question, the problem with this is that it too assumes that medical care is an exact science, that you can actually rule something out. And so this is most problematic in patients where you have postoperative problems or problems actually related to the surgery. And let's say you're trying to, the proposition is that you had a duty to rule out infection. Well, there's all sorts of things and markers for infection, but those markers can be indices of other medical problems. And so you can't always rule out a problem. So I object to this question in a deposition because it's unfair. It's not the obligation of the care provider to rule out. And so the best answer to this question is we don't rule out anything. Differential diagnosis question is the kissing cousin of the rule out question. And that is, and the plaintiff's bar loves it because if it was high on your differential, the problem, let's say the post-op problem was high on your differential, you didn't properly diagnose, or I'm sorry, you didn't properly treat it. If it was low on your differential, you didn't properly diagnose it. And so it's a no-win question. And the best answer I can give to anybody is we don't make differential diagnoses. Really, the only people that list differential diagnoses that I'm aware of are medical students. And medical students should do it because they're the ones that really need to go through and comb through those various things that might be causing the patient's problems and maybe make a list. But beyond that, most of the surgeons that I deal with aren't sitting there making differential diagnoses, but the plaintiff's bar love this. And these are things to watch out for. Literature is used in every deposition. Your ask is a particular text or something on up to date. Is it authoritative or is it reasonably reliable? In Illinois, it's reasonably reliable, and that's probably the standard, something like that throughout the country. You have to avoid, and I'm sure many of you know, you have to avoid indicating that there's anything that's reasonably reliable or authoritative, because you don't want to vouch for everything that's out there, and you don't want to vouch for something you haven't seen. If there's a particular piece of literature that somebody wants you to at least make a stab at determining whether it's authoritative, I usually say to the plaintiff's attorney, give us the document. We're going to take a break. We'll take the next 45 minutes to an hour to read this literature, and then we'll talk about whether it's authoritative or not. That usually shuts it off right away. But if you agree that some piece of literature is authoritative, it's just going to be used against you at trial. That's all they're using it for. This is an example I use. I'll skip through that now. The loop is something that happens that you've all experienced if you've been in deposition. The plaintiffs will ask a series of questions. They get to the what I guess I would call the money question, which is standard of care type question. They don't like the answer because you've done what I've asked you to do, and you've said, well, maybe, possibly, I can't really say for sure. And then they just go right back to the top and they go right back through the same line of questions again. And they keep going through this loop and loop, hoping that you'll just wear down and finally you'll say, okay, I give up, you're right. And so this is just a tactic that you can, as long as you're aware of it going into the deposition, you'll be better equipped to deal with it. This is another example. I always tell my clients the tough questions come at the end. If I'm the plaintiff's lawyer and I'm getting frustrated, this happened to me yesterday. He was getting very frustrated because the expert wasn't giving him anything. And so they want to leave the deposition with something. So what they'll do is they'll indicate things like, doctor, I just have a few more questions, or I'm almost done. And so if you're the defendant, what you start to do is, instead of waiting 3 to 5 seconds to answer the question, what you start to do is speed it up and you start looking at the door and you quit paying attention and you start answering yes to questions that if you look at the transcript later, you go, why did I ever say yes to that? And so they know that this is all psychology, and they will wait until the end to ask you the tough questions until you're worn out and your guard is down. So I always take a break, tell my clients, look, you got to play the whole game. Just like you were taught in school, in sports, you got to play all 60 minutes. You got to hang in there and play the whole game because the tough questions are coming. The last thing I guess I'll say about this is it's very much human nature to go into a deposition and want to defend your care. And you have to drop the defense mindset. You just have to drop it. Because if you have the defense mindset, you're going to say things on the deposition that they're going to use to just beat you up at trial. And so what I want my clients to do is to focus on these questions and focus on these questions alone and drop the defense mindset. Quit being defensive. Quit trying to explain what you did. Just answer the discrete questions with discrete answers and you'll do well. That's all I have. Thank you.
Peter, thank you so very much. That was excellent. Before I introduce Dr. Harrop, I do want to say that please use the question and answer function. Type in your questions there. You can be anonymous if you'd like. And Mike Lee will lead the discussion at the end on the Q&A. Our next speaker is Professor James Harrop from Jefferson. He'll do part 1 on the surgeon's perspective. Jim? Are you unmuted, Jim?
Sorry about that. Can you hear me now?
We got you.
Thanks. Peter, that was a great talk. Thank you very much. You did a great job. You summarized a lot of the points that I think are just things I learned over the years. And I'm like, God, where the hell was that guy 25 years ago? So with that, I just want to say I have a little comment about the consent on the last part of my slide. I do think that managing expectation is something you learn as you get older. It's very interesting. So my degenerative scoliosis cases, which is one of the toughest cases we do, I used to tell people, there's a high percentage of chance you're going to have a problem. And the problem with telling people that 99% is patients always think that they'll be the 1% that has no problem. So my new tactic was, and I learned from Alex Vaccaro, he taught me this he tells his lumbar disc patients this, that they'll have 100% chance of having a complication. That way and I usually tell them, just pick which complication, pray you get the urinary tract infection instead of the death. But I think it really does help people sort of say, okay, let me step back and think of what I'm getting into here. And I know there's going to be a complication because everyone, you always think it's the other guy that's going to win the lottery. But in spine surgery, unfortunately, as you pointed out, 30% of our patients don't do as well as we'd like to. So that last thing is I should probably throw up my disclosures here. Okay, my slides aren't advancing. My disclosures, I do also do medical review for plaintiffs and defense. And I totally agree with you. There's nothing harder to defend someone when you're looking at a chart and there's nothing in it, because the lawyers on the other side who are saying you did wrong, they have an open slate. So I really think it's important that you have these discussions, and even more important to document them. So with that, really quickly, and I know we're sort of a little bit on time here, I'm going to go through quickly just quality of care, because if you step back and listen to a lot of what you said, a lot of what we're talking about is quality of care. I'm going to go through some of the reforms, some quick definitions, but I'm going to probably skip over a lot of that because you guys already had your first course. Then we're going to talk about medical malpractice suits, and I'm going to break it up a little bit differently in how I think about things. And if you ask me about the flaw of the system right now, and I'm going to use the word process, and I'll explain that in a second, I think the expert witness is probably the area that we could do the best on improvement. And that's not on the plaintiff's lawyer, and it's not on the defense lawyer. That's on everyone in this group and us doctors sort of policing ourselves. So with that is, I recently got a master's in quality improvement. I think it really changed the way I look at the world and how I think about world. You know, one of the big problems when we look at our healthcare is we have a huge gap, an increasing gap of how much our gross national product is spent on medicine. We're actually up to almost 19% of our healthcare dollars in 2021 is spent on healthcare. Now that's a great thing, but the problem is although we're spending 19% of our GNP on healthcare, we have very poor value. And what do I mean by that? The life expectancy in the US is 4 times more expensive than otherwhere. And you can look at any other quality metric you want. You usually get the same result in the US for 4 times more. And the big egotistical American answer is, well, you know, we're better, we have this, and we teach the world and everything. And it's really not. We don't spend our money as well as we can, and we spend a lot of things on things that we should improve. And I'm going to argue that probably one of those areas that we spend a little bit too much money is on the legal side. So that goes into healthcare reform. And one of the ways I think we have to change the world in the process of medicine, not the whole process of the legal thing, is we need to look at better ways to do this. And this is an old paper, 2009. They're talking about $151 billion on healthcare dollars wasted for defense medical spending. I can tell you, and Peter can answer this, and Alex, is the first thing when you're sitting in that oak box, what they love to ask you is, Dr. Harrop, in that patient, if you got an MRI, you know, they always ask you, is there another study that you think you could have gotten that might have helped you out? And of course, they're asking you about the MRI, but the MRI costs a lot of money and the patient's got no indications of needing an MRI. But the problem is you're working for the back end. And, you know, Peter, you mentioned the safety question, and I love that question. You forgot to tell us how to answer it. So and someone answered it on the question. I can't wait to hear the answer of it, because it's exactly such a great lawyer question. You're totally screwed no matter how you answer it, at least the way I would think of answering it. Because if you answer it one way, you're saying, well, I didn't do something safe. And if you answer it on the other way, you're negligent. And so it's a great question. It's a very, you know, hindsight's 20/20 in most of the cases. And the reason they're asking you about discharge and safety is because guess what? The guy went home and something bad happened. Otherwise you wouldn't be, you know, getting interviewed. So, you know, this all comes down to tort, and I didn't really totally understand what tort was and what it means. And you hear that word a lot. And basically, to summarize, it's a wrongful act. And tort law is a discipline of law. And I'm not going in this, but I'm hoping you guys got this talk about this, is about that. A little longer history is this all comes back from English law. So our you know, if you have any English friends, you can bring them. The Magna Carta, they gave this also to us. And it wasn't that long ago. It's only 250, 300 years that medical malpractice has really been going in. Causation, damages, and recovery. You should know these terms, and I'm more than happy to give my slides at the end of the talk for the LRS, and you guys can have them and go through them or ask us later. The requirements, and this is kind of interesting, and I learned this earlier in my life, and I thought it was kind of interesting. You can do gross negligence on a patient. I mean, you can put feces in their wound, and if they don't get a wound infection or have anything bad happen to them, it's really, you can't, now Peter's going to argue with me, you can't have a legal trial because you need to have you need to have negligence and you need to have an injury. And you got to get those two things. And so when you deal with, they're going to talk about causation, and that's a breach of what happened, and an injury. And so when you're doing medical expert things, people will also refer to you as, I need you to address causation. I need to address the injury. I need you to address something or another. So again, just a couple of trials. And this is really when you really don't know anything, and every state is different. And I've sort of been lucky or unlucky, and I've been in many different states and have defended many doctors in different areas. And it's interesting how different states do it. In Philadelphia, which we have somewhat liberal court system, you actually have to get a physician to sign the what we call certificate of merit. And that's actually before you file the lawsuit. Now, Peter, in Chicago, you do it a little differently, which actually I kind of like, but I kind of don't like, because that means you can throw anything up against the wall and wait 90 days.
Yeah, we have the same certificate, certificate of merit requirement.
You have that also?
Yep, we do.
Yeah. And that's somewhat of an interesting thing, because there's somewhat, in Philadelphia, you have to, that gets hidden away. It gets put in an envelope and no one ever sees it. And so I think one of the things we need to do as a society is go back. And once you get sued and it's over, everyone sort of says, oh, I feel great. I want to forget this behind me. But I think you got to go back and say, particularly what we consider not really lawsuits that should have started, is go back and find out, okay, who did the merit? Why did they do it the merit? And was it a valid merit? I will tell you, in the city of Philadelphia, there was one gentleman lawyer who didn't do this. And he actually got sanctioned by the Bar Association because he just filed them all and said he had the merits and never had them. Then he falsified some documents, which again, we don't like to see on either side, but I do think it's a part of our thing. The discovery phase is, that's what Peter was talking about. That's where you send out all the records and you get other people to opinion them. And you might not know this, but what happens is when you have a medical lawsuit comes out, and even sometimes before it gets sent out, is they send the chart out to 1 million doctors, usually between 2 and 3 different neurosurgeons, to get the opinion to find out, is this something I should settle, or is this something I shouldn't? They'll also try to figure out, a lot of times, as Peter and I were talking about earlier, sometimes they'll try to settle the case earlier if they can. And that's more in the pre-trial phase. One of the things we didn't talk about, at least on the Philadelphia, there's a lot going on with what we call high-low arbitration, which is a newer philosophy. It's kind of an interesting thing. And basically what you do is you set the low bar at the cost of what the plaintiff's lawyer's cost structures is, so he doesn't lose anything, or maybe makes a little money by doing the case. And the high part is sort of high, but not out of control, such that, again, a lot of what this is talking about is accounting, because, what happens is you pay your insurance every year, and then they have to pay, not that they have to pay it out, but it gets paid out. And so to control the cost is very helpful for the insurance companies. The next thing is, I really just want to quickly go over this, and we're going to talk about the expert witnesses. But before we do that, I just want to go over this right now. This is an interesting paper. It's in Neurosurgery Focus in 2020. And the neurosurgeons have probably been a little bit more sensitive about lawsuits and probably a little bit more targeted than the orthopedic surgeons. And it's kind of interesting, if you look at in the state of New Jersey, if you give up your head privileges, you actually save money. And so there's 2 really quick misconceptions I want to throw out there if you're a neurosurgeon. One is that trauma has a high legal cost. Many studies have looked at it, and trauma actually does not increase your legal exposure. And number 2 is doing cranial work does not increase your legal exposure when you go out there. So unfortunately for the neurosurgeons that only do spine, and our orthopedic colleagues that do primarily spine, probably it is the most vulnerable area for lawsuits. But really quickly, this goes through, this paper goes through every single state, and it has all the states listed out there. And it looks at, as I said before, what are the processes that are the best in terms of medical legal reforms? And one of the things we forget about this is, I have no problem if a patient's injured. And I think the other part of the team that's not getting full credit or getting all their money or getting as best as they can is, patients, bad things happen as part of our surgery, as part of neurosurgery and orthopedic surgery. And I think one of the problems is we spend all this money on lawyers and depositions and everything, it'd be a lot nicer if we could help the patients that have problems rather than sort of spend all the money on the legal process. So anyways, these are the cases out there. The excellent states have what? They have a medical panel review. And basically what they do is they go out there and they try to find out, is this a valid case and is there a claim? And those are the ones that have the best, and those states have the least malpractice costs for the nurse, This is actually a neurosurgical article. The second thing is they talk about economic and non-capping damages. And again, that's another way to cost, but I didn't really want to focus that. Now, the great state of Illinois and the great state of Pennsylvania happen to be on the really, really bad states. And I got to tell you, it cracked me up because I looked at the average cost they say is 100. I don't even know what it is. I can tell you before, when I paid my own malpractice insurance, it was $365,000 a year. And I have never had a claim against me. So it's very interesting. I don't know where they got these numbers for. But again, the problem is at least in Pennsylvania, you need a constitutional reform to get tort reform or anything. So it's not changing, but they didn't have a review. Anyone can charge anyone. And it's completely, it's complete luck. So if you get a good jury and you have an injured patient with no malpractice, guys and girls will file anything because again, it's like hitting the lottery. And so people are very willing to send things out. This is in case you're an image learner. It's kind of interesting too. This is based on it. Really excellent is blue and poor is red. And it doesn't follow the patterns you would figure it does on political lines. So it's kind of something I think we do need to get the overall process improved. And I'm coming to the end, so I'll just go through this really quickly. Last thing I just want to say about the expert witnesses, our societies are our friends. And the AANS, as many of you probably don't know this, actually were the first ones to really peer review their own people. And they sanctioned someone for false testimony, false expert witness. And the AANS, and one of the things just so everyone knows, is in order to be an expert, you need to review the images yourself. You can't base your reports on a radiology report. So if you're going to do expert review, you need to understand the expert opinion, the expert criteria of the societies you belong to. And I know that CNS, AANS, and NAS, and I assume the AANS does, I'm almost positive it does, has an expert witness statement of what your responsibilities are if you're going to do a expert witness or you're going to help testify for someone. I strongly encourage everyone to review it because again, I had one deposition and the plaintiff's lawyer actually had me read line per what it was. I think he was shocked that I actually knew everything in it. Lastly, real quickly, this is the standard Jefferson consent. And there's many different attitudes about the world. The standard Jefferson consent basically has your name, what you're doing. I can give you blood. I can take pictures with you and then write in the rest of the surgery. Over the years, there was a guy named Fred Simeone who trained me. He went out and he has a consent that he made. And so what we did is I took his consent, I took Alex's consent. Our consent is 9 pages not long now. Now there's a bad side of that because Peter's going to say, well, that is so long that people don't read it. But the interesting thing is I give the patients 2 consents and I say, here's your consent. I go, you need to read this. You need to initial every page and you're getting a copy to bring home with you because I don't expect you to read it today. And I am happy to sit down with you and go over every line. And you'd be interesting. About probably 10% of people come back and they'll circle something or they'll tell me my English is horrible and I need a period on this page. You can tell. But I do think it gets back to your original statement, Peter, is communication is key. And I think communicating with people is probably the best thing we can do with it. Now, you're going to get sued. Here's the bad news in the summary of the whole thing. You're going to get sued. If you look at a neurosurgeon gets sued every 3 years. Philadelphia is every 3 days. So you're going to get sued. And so I think the worst thing for you is a huge blow to your ego. And I remember I got sued, God knows for what. And my buddy is a businessman. And he looked at me, he goes, you're an idiot. He goes, I get sued all the time. It's part of doing business, Jim. I go, I get someone slip in my store all the time. I get sued all the yin yang. You don't understand. This isn't an emotional thing. It's a business. And I think that took me aback. And you got to remember, yes, a lot of it is. And just to go back, I'm going to say one quick thing and I'm going to end, is I think we get sued for several reasons. One is what I consider the money grab. Someone just wants to make money. And that's going to happen. And that's, to me, that's the easiest one to take. The guy or girl, whatever, had a good outcome, didn't have done. And here's the funny thing. If you do workman's comp or your patient has a lawyer, you're 8 times more likely to be sued, just so you know. Number 2 is, and this is the one that we can do better, the arrogant doctor. A lot of patients sue their doctor because they find them arrogant. They didn't listen. In the classic one I have, and particularly if your patient's a nurse, they tell you the doctor didn't listen to me. And so be very careful and listen to your patients, particularly if you have a complication. I mean, I can tell you on my speed dial, most of my complications are on my speed dial on my phone because I tried to call them every day. And the attitude is you're going to get sued or not sued. I mean, take care of the patient, get over it, and just try to do the best for them. And so with that, I'm ending up, and I got a little slide for an introduction for Alex's talk. Thank you very much.
Jim, great job.
Thanks, Jim.
Thank you.
Alex, you're on. Alex Vaccaro from Rothman, the other part of Jefferson.
Okay, let me share my screen with you guys. So Peter and Jim have done a great job. Can everyone see my slides? Can you guys see it? Good. Okay. So what I'm going to talk about is to synthesize what Peter said and what Jim said. And again, Peter, I'm just going to hit you with my questions now. I didn't really get when someone says, let's talk about differential diagnosis. And you said, we don't have to talk about differential diagnosis. And the other thing, I forget the other thing. So you got to give me a way to answer that question. So that's my question at the end. But I'm going to give an overview. These are my conflicts. One of my major conflicts is I have been sued. I have been to court. And it's been interesting. That's my conflict of interest. So to give you a perspective, let me just, a physician looks, as Jim just said, litigation, random event. This is crazy. Everyone's trying to hit the lottery. And this is sort of an example. If everyone, I'm 59, I'm sure, Peter, you look like you're 40, Jim, you're about 26. So these are the movies we look at. I want to show you an example of what I believed when I was younger, the whole litigation process was about. Now, Jim and I and Peter know it's different, but this is how we may believe it, especially a young surgeon. Watch this video.
Wish you can. Forget it. You can't get out of bed. Wait, I can't go. Who says? Hate to break it to you, kid, but you got a spinal injury. What? Your left leg is numb and you got no feeling in the first 3 fingers of your right hand. You're crazy. I can move my hand and my leg. Sure you can if you want to blow $1 million. What are you talking about? That's what we're suing for. They'll offer us $100,000. We settle for $250,000. They're smart, but I'm just as tough and I know all their tricks. They're going to hit you with hammers. They'll stick pins into you. Not me. All you have to remember are which nerves are damaged. From the middle of your ring finger to your thumb, you're numb. As for your leg, don't lose yourself in details. I don't care if they get 100 doctors to examine you. If you say that your back is killing you, they can't prove it isn't. That's what we call pain and suffering. And the money you get for that is tax-free. What?
Well, tell me when this feels sharp and when this feels dull.
Sharp. Sharp. Dull. Dull. Sharp.
Nurse,
Yes.
there must be a lower back injury as well. Get a hold of Dr. Montgomery. I want some more x-rays, and let's get ready for an encephalogram, an EMG, and if necessary, a spinal tap.
Yes, doctor. Anything I can do. Pray for him, sister.
So that's what a lot of us walk into. We don't trust attorneys. We don't trust patients. If anything goes wrong, we hide. The plaintiffs look at us totally opposite. A typical doctor whining. He's not looking out for his patient's best interest. We need more litigation. We need to get rid of the rules. All the things that Jim and Peter talked about, just a waste of time. We're not protecting patients' rights. And politically, we see the Republicans go one way. We see the Democrats the other way. Physicians don't police physicians, and we blame it all on you. And what is the truth? Well, we know what the truth is, that we really haven't figured out a way of promoting safer medicine and appropriately compensating injured patients. And Jim took the perspective in his talk saying, listen, if something goes wrong and the 4 tenets of a lawsuit occur, you have a relationship with the patient, there was a deviation from the standard of care, it caused injury and you have damages, well, then you have a legal action, you have a tort that should be compensable. And I think we all agree on that. And Jim went over these things, and Jim made the concept, well, if you perform a negligent act and it doesn't cause damage, well, then it's not a lawsuit. Well, I've seen that not be true in Philadelphia. One of my friends stuck an arthroscope in the wrong knee. Okay, that's negligent. They deposed the patient. In the middle of the deposition, the defense attorney said, the knee they stuck the arthroscope in, it was your left knee, correct? Yes, it was. And he was supposed to scope the right knee, correct? Well, how's your left knee doing now that got the scope? It's doing good. I have no problem. Motion to dismiss. There was no damages. The judge dismissed the case. And the attorney said, in about 9 seconds, I'm going to make a phone call to the Philadelphia Inquirer unless you pay me this amount of money. And a settlement was made. So in reality, don't commit negligent acts. You think you're going to walk away because there's no damages. It's not going to happen. So as Jim said before, the vast majority of us spend our life in a lawsuit. In the city of Philadelphia, if I get sued, it's 5 years. They don't even get around to the depositions for a year and a half, 2 years. It goes on forever. And I'll tell you, it just gnaws at you. When you first get that lawsuit, you're nauseous, you're depressed. 3 or 4 days, you start pulling out of it. You start talking to your family again. You stop hitting your wife. And then you start focusing on what's important. And then nothing happens for a year and a half. And then you sit down. So, and as Peter and Jim said before, there's so much waste in the system. 65 cents on the dollar goes to somebody else except for the injured patient, which is amazing to me. And keep in mind, the plaintiff attorneys are correct. Only 2% in general of negligent injuries result in claims. And what gets us mad, only 17% of claims involve a negligent injury. So that's the conundrum. And I'll get to my conclusions of what I think we should go, which is totally different than what Peter and Jim said, but I have an idea of where we should go in the future. Now, 2011, who got sued all the time? The neurosurgeons, but the general surgeons paid out more. Now it's changing. If you look at it now, orthopedic surgeons are getting sued more than neurosurgeons. And I believe the reason for that is the neurosurgeons really focus on this problem and they police themselves. They're okay with you getting sued because a negligent act occurred, but they do not tolerate if someone files a frivolous lawsuit and they stand behind each other. And all the specialties have to do that. So if it's negligence and it's inappropriate, compensate the patient. But if you're not, that's why we have societies that have rules. So we have to keep an eye on that. Now, unfortunately, in orthopedic surgery and neurosurgery, as Jim said before, it's a spine surgeon that gets sued the most. It doesn't matter if you're a neurosurgeon or an orthopedic surgeon. Orthopedic surgeons usually have larger payouts because we can't count to 10. So that's the reason why that happens. But we get sued equally, just as much between itself. And informed consent is a big problem. Almost 25% of cases. It's more common in the lumbar case because lumbar cases are the most commonly operated on. And this is just an understanding. It's usually a technical problem or nerve injury. You get a dural tear and there's no nerve injury, you will likely have a defense verdict. You get a dural tear, delay in diagnosis, delay in treatment, and a neurologic injury, you're probably going to pay. Now look at the averages of time. That's a lot of time to hang out in a case, and that emotionally wears you down. And then what you're afraid of is once you get served, oh my God, I hope I don't get served again. Oh my God, I got served again. It just comes with the territory and it really depresses people. So, you know, I love the articles that say getting a dural tear is part of doing business. And I love when the plaintiff attorneys get together and the plaintiff attorneys hire physicians to do systematic reviews on why dural injuries are negligence or what is the definition of cauda equina syndrome. Whenever you see an article written on the standard of care by an MD-JD, be wary. So if you look at these things, you're going to probably lose if you have a dural tear with a nerve injury. But if you repair it, you do the best you can. And if it's not a good repair and it leaks again and you go back right away, you're going to win that case if a medical lawsuit is brought. So just be attentive to care. Now, if you look at who wins these cases, failure to treat, death, emergent surgery is bad. Now, I hang out with plaintiff attorneys and they tell me all the time, you know, I know what you do is dangerous, but I had to take the case because the patient was paralyzed. You know, I don't even know if there's negligence, but there was a death involved. You're probably going to get sued. You may win, you may lose, but you're probably going to get sued. So the more catastrophic the case, the more likely it's going to be brought against you. So keep that in the back of your mind. Now, if you look at verdicts, the verdicts are all over the place. Now, as Jim talked about before, I read that neurosurgical focus group on what prohibits a large payout, and caps do minimize payouts. But catastrophic complications today can go anywhere from $2.5 million to $10 million, which is a big, big problem. So as Jim said before, when you get sued, You don't wear your heart on your sleeve. Make sure you have a relationship before you get sued with who your group uses as a defense firm. I'd get to know them. I'd take the attorney out to lunch if I were you. Get to be on a first name basis. You don't want to feel like you're the forgotten child. Have a first name basis. Talk about the case. Just don't send records. Let risk management know exactly what's happening. And don't make, Jim didn't talk about this, don't make the cardinal mistake. Don't go back and saying, well, I think I charted this. Let me just make sure the chart is okay. When you use electronic medical records nowadays and you go back in to look at a chart, they know you went back to look at a chart. There's metadata. Anything you do, anything you touch is looked at. Hey, doctor, I see you went back in this chart 11 times after you were sued. Can you tell me why you went on this suit? Well, because I got sued. Well, why did you go back? They'll ask those questions. They'll ask it just to embarrass you. So keep that in the back of your mind. As Peter said, you better know your deposition inside and out. You never want to contradict your deposition. So think clearly about what you say. There's only 3 acceptable answers in a deposition. Yes, no, I don't recall. If you make the mistake of educating the plaintiff attorney, you've just lost that deposition. You're there to give honest, concise answers and not to educate anybody. And make sure you read every fact in that case. Make sure you read every single deposition that's out there. And let me tell you another thing. If you think you're smarter than the attorney, you may know the medicine better, but you don't know the law better. You will never win a lawsuit in your deposition. You will only lose your lawsuit. If you do great in a deposition and your attorney said you did phenomenal, that just means you didn't hurt yourself. Doesn't mean you won it because it's a money game, as Jim said. So be focused. Don't point blame on anybody. And remember, what you say will be edited. If you have a tick, if you repeat yourself, I love when they do the depositions, they want to videotape. You know what that means? Let me tell you what it means. And I've been in those depositions. Doctor, is it true that you were wearing blue jeans at your deposition? Yes, it is true you were wearing blue jeans in my deposition. Then at the courtroom, they go, doctor, let me ask you a question. Were you wearing blue jeans at your deposition? I go, yes, I believe it was. Well, let's go to the videotape. They love saying, let's go to the videotape because they want to show the jury how you're and literally with my depositions, they're showing the same thing I just said. I go, well, that's just exactly what I said. So be careful. It will be edited to make you look like a fool. Now, here's an example of a deposition at Thomas Jefferson University that I'm embarrassed by. This is a complication that occurred to a doctor's patient. And this doctor, and I don't disclose his name, is going like this. And a friend of mine who Jim knows very well, Joe Mesa, is the plaintiff attorney. Now, I want you to follow exactly how this goes and what you never do in a deposition.
Were there errors made in the care of Mr. Guinness while he was an inpatient at Thomas Jefferson University Hospital? Can you answer the question, doctor?
In terms of what I would expect to occur based on certain events that I was told, I wasn't present for a lot of these events. I would have expected different things to happen. And that's what's disappointing about this case.
And what different things would you have expected to happen?
I would expect to have been notified on a number of occasions from a number of different parties so that I could have been directly involved as opposed to have been called after the fact.
So that deposition just pointed fingers. It didn't help anybody. It didn't help that gentleman. And that was pointing fingers. And that's one thing you never do in a deposition. So when you walk into a courtroom, don't drive up in your Maserati. Don't drive up in your Porsche. Don't have the fanciest 3-piece Italian suit. Be humble. Take your time. Take a deep breath. Answer every question honestly. Now, in terms of tort reform, Peter and Jim talked about different ways. And there's many different ways the courts have limited the amount of frequency and the amount, limit access to the courts, decrease claim frequency and caps and so forth. And Jim mentioned screening panels. You could shorten the statutes. You could have statutes of repose, which means it starts the minute the plaintiff should have known an injury should have occurred. We have joint and several liability, which drives me crazy. Jim Harrop may be 1% guilty and the other party's 99% guilty, but Jim has the money. Guess what? Jim pays the entire fee. It is crazy. Certain things speak for themselves. Res ipsa loquitur. You leave a sponge in, it shouldn't have happened. We have stricter expert witnesses. In a spine surgery case, I've been in some courts when a non-spine surgeon who's a general orthopedic surgeon can testify against a spine surgeon. That is crazy. These are the things that happen. Now, so how do you limit the amount of payment? Cap, which allows the insurance company to have an understanding of any outlays of money. That makes sense. Regulating attorney fees. And if you look at it, and I'll go into what the scientific studies show, you could mandate collateral soft offsets. Like say this patient's going to get a payout from workman's comp, who's going to get a payout from his workman's comp. And then the verdict against you is for $1 million. Well, it can be offset by other forms of payment. It could be periodic payments. In Philadelphia, they would say, oh, even though this negligence occurred in the suburbs, but you're a professor in Philadelphia, let's go to Philly, 80% chance of losing with the plaintiff. So that's where the venue is. So scientifically, this is from that article that Jim talked about before, caps really do decrease care. I was shown a case in California where there was negligence and a patient had an injury in the operating room, and the plaintiff attorney called me and said, I'm not going to take the case because the patient's not working. I can't get anything. In Philadelphia, that would have been a $15 million case. Caps means something. The relationship to the premium is unclear. So increasing, decreasing premium is unclear and how it affects the amount of payments. Collateral offsets do decrease payments. Shorter statutes make sense to me. In New York, it's 3 years. Here it's 2. I would love to have a 1-year statutes. And screening panels, most of the studies show it doesn't make a difference because if someone really wants to file a case, they'll keep on coming at you. They'll keep on coming at you. We don't have it in Philadelphia. I would love to have it. So let's talk about different ways of coming to an understanding. So one way is a system approach to decrease medical errors, locating responsibility at the institutional level, determine if it's a system error or physician error, and insurance to compensate malaccurrence. Now, these weren't talked about today. I think medical malpractice should be based similar to workman's comp. If you're injured by something that should have been avoided and you have an injury, why fight it? I've seen patients who are quadriplegic lose in lawsuits because the defense was great and the plaintiff was poor. That's wrong. That patient should have won money. So handle it like a workman's comp case where you take the concept of negligence away. Hospitals can police their physicians. So if the doctor's negligence, they could lose their license. They can go in front of a committee. But it's a fast track operation where you say the loss of a thumb function is worth this much amount of money in a worker. That's how much it's worth. We all pay medical malpractice workman's comp because it should have been an avoidable thing. And again, standard of care is looked at by the hospital, looked at by the medical societies, and you can be prosecuted for that. But the patient gets compensated, so it's not a war. I have been a defense expert in cases where the plaintiff should have won, but the plaintiff got greedy and they lost the case. And that's not fair to the patient itself. So there's other ways. Early offer programs. We're not really big at this at Thomas Jefferson. I think this is a wonderful thing. If you do the wrong level surgery, you did the best you can, but you counted wrong. Sit down. Early offer. If you don't do an early offer, it goes into litigation. You don't know who's going to win that case. Arbitration is okay. I'm not a big fan of high-low because you're paying out someone. So I'm a big fan. If negligence is committed, you pay. If negligence isn't committed, so I'm not a big fan of high-low. It does make it more understandable what the payout is. And I'm a big proponent of medical courtrooms, making every physician, just like being a jury, have to spend 1 week out of the year reviewing cases. You don't necessarily have to go to court. It could be by Zoom, but mandating to keep your license, everyone has to be a member of that. And I think that's the most effective way of judging your physician. You don't even get paid for it. It's mandatory. You have to review 3 cases a year, predefined values for loss. You compensate. And here's the big thing that the British system does well. If you get sued and you're exonerated, there has to be a way of compensating you for your time and energy, which we don't have in our country. So that's sort of a summation from where we are, a little bit of humor, and what I think the future should be, because this problem is getting out of control. One last thing, New York Times did an article this weekend. Medical malpractice insurance is cyclical. We're going into a bad insurance cycle. So everyone's rates are going to go up because the payouts are going to increase. And because of the COVID crisis, so even if you don't commit negligence, Jimmy said he paid over $350,000. Our costs are coming up. It's non-sustainable, and the only person that's going to lose is the patient. So thank you.
Great, thank you, Dr. Vaccaro, Dr. Harrop, and Mr. Brandt. That was a fantastic set of presentations. Just to go into the Q&A, if you have questions, please enter them in the Q&A. Peter, there was an early question on by Jacob Bukowski from WashU who asked, how do you answer the question, was it safe? Was it safe to discharge that patient knowing that it's hit a slight leukocytosis? Was it safe to discharge that patient with a little bit of leg pain? And like Jim had mentioned, it's kind of a tough question because if you answer it, you're kind of damned if you do, damned if you don't. How do you advise clients to answer that question?
My advice is to answer the question with a question, and that is, how do you define safe? Because if you make the plaintiff's attorney define what safe is, then you can answer the question. Because it would be safe for you to walk your patient out to the car. It would be safe for you to go home with your patient and make sure that they take their medication on a regular schedule. That would all be safe. But if you don't have a definition, there's no parameters. And so typically, if I'll either butt in and ask the question myself, but if my client asks, well, what do you mean by safe? We need a definition. They drop the question almost immediately because they don't want to define it.
Peter, I'm gonna answer you, okay? So I would define safe, sir, by you discharge your patient with a fever and a leukocytosis that they go home and they don't die.
Yep. And so,
And your patient died. Can you come back to me and explain to me, do you think it's safe to send your patient out with a fever and a draining wound?
to which I would certainly instruct my client to say, sometimes it is and sometimes it's not.
Okay, I like that.
Okay, Peter, let me
It
ask
really
you,
depends.
give us the answer on, doctor, what is your differential diagnosis? And you said you don't have to answer it, but if you say that, it sounds kind of weird in a deposition. So how do I say, I'm not going to give you a deposition? And I forget the other thing you said, where I said, how do you say no to a plaintiff when they ask you? What was the other thing you said?
So there was two types of questions that the plaintiffs really love. And the first one is rule out. The other one is differential diagnoses. And so the answer to the rule out question is we never rule out anything. And so if you respond that way and you think about it, if someone says, well, doctor, did you rule this out? And you say, well, we didn't rule out anything. We don't rule anything in and we don't rule anything out. What we try and do is make a diagnosis and then move forward. It really takes that rule off, rule out or rule in question off the table. The same with the differential diagnosis. If you say, I really don't make differential diagnoses, I attempt to make a diagnosis. So I don't list the probable or possible things that might be going on with the patient. What I try and do is reach a diagnosis. That takes the differential diagnosis question off the table too.
I like
Just,
that.
you're just playing chess and you're just moving chess pieces.
Great.
Yeah, I would come back and say, well, doctor, hypothetically, could you list me the most probable causes of this patient's time at this course of his hospitalization?
Jim, I don't list probable causes. I list the cause, but thank you very much for asking.
We spent some time talking about consents, and I think this came up in the last session, but a lot of us have physician extenders, APNs, PAs, who will sometimes obtain consents for us. Peter, are those regarded, well, how should we approach those and how are those regarded from a legal perspective?
So you're talking
Answer that
about
one for you from you.
Anyone, I guess.
Well, in Pennsylvania, I can answer this one because Peter probably knows this. Pennsylvania had the Pennsylvania Supreme Court actually, there was a Geisinger case where the PA actually signed the consent. And so I think it's a state by state issue. But at least in Pennsylvania, as of now, physician extenders are not allowed to get consent or they're not valid consents. The bigger question becomes is what about residents? Residents are actually MDs, but the Supreme Court in Pennsylvania, which is, and Peter, correct me if I'm wrong on that, this is viewed that if you're not a physician, you don't have the knowledge or the communication or relationship with the patient to establish informed consent.
I think it does vary state to state. In our state, it doesn't make a difference. You can have the PA or the nurse practitioner provide the informed consent. Again, the important part for me is, did they document what was discussed? So it does vary state to state. Either way, the important thing about the informed consent document, the actual document itself, which Jim brought up, the thing is that what I find is when I speak to jurors, and this might seem incredible, but if you sign a document, most jurors are going to say, well, you signed the document. You had an opportunity not to sign it. And so you're going to be held to that document. And so they'll all admit and they'll all agree that they don't read them. I've signed it. The nurse comes to you when I'm going into surgery and says, sign here. They sign them, they don't read them, but they will also hold a patient to whatever they signed. And it's it's just more of the American way. I think that if you sign something, you've agreed to the terms. It's interesting.
Interesting. Question for the clinicians. A little bit of a touchy-feely question. Let's say an adverse event occurs, and you, I think both of you mentioned this is the kind of person you have in your speed dial. You're checking in on them, really taking care of the patient. How do you talk to the patient? And I guess what I'm getting at are specifically are apologies. You know, several states have apology statutes in how you say things and what kind of verbiage can be used against you later on. And Peter can chime in too. But how do you approach that patient for which an adverse event occurs? Do you choose words carefully in how you interact with them, or how do you approach that patient? Let's start with you, Alex.
Yeah, so that's a great question. So I always say, I'm really sorry for what happened to you. And it doesn't mean I take responsibility, because I may not be responsible. Once you, because every state has an apology rule, but I always say, I always identify what happens. I always tell them how sorry I feel it happened to them. I tell them the next thing. I have 4 components: what I've done to rectify or improve the situation, and then what I've done now to improve the safety situation so it won't happen again. So identify the problem, apologize, what we're going to do to take care of you, and what we're going to do in the future to make it feel better. But I do not take responsibility if I wasn't the one that was responsible. I don't put it on anyone else. I always say, I'm really sorry this happened to you. And I'll give you a true life example. And Jim knows this example. And we won't mention the plaintiff. A very, very famous plaintiff attorney who's very effective had something happen to him at Thomas Jefferson. And it occurred by one of my partners. And I apologized to that plaintiff attorney. And I said, I'm really sorry you went through this. And when I tell you that, a plaintiff attorney went off on me. He really got angry with me, which was never really happens, because I didn't list specifically what I was sorry for, because he was going to use it against me, because that's what they'll use it against you. So you don't have to say specific. You just say, listen, I'm really sorry. And 99% of people will like it unless it's going to be used against you. So that's been my experience.
So yeah, and I'll go on that further. I find that you should be the communication with the patient, because I've had patients where they're in the ICU and, you're down the tree and someone else is telling them, oh, that's because Dr. Harrop put the freaking screw through the aorta. And you're like, huh? And so, I mean, I call the patient, I talk to the patient, and I think, one of the things that I'm not afraid of, and I think patients respect it, is I say, I don't know. And the second thing is, I believe, Benzel used to say this. He said, when you're in troubled waters, fly as a flock, because it's hard to shoot one bird down. And so I think I get a lot of people around me, and I try to get everyone to get the answer, and I try to direct the narrative. And really what you try to do is help the patient, because, a lot of us, you get sued and you want to be a turtle. It really sucks going in there. You paralyze someone, that next day walking in the room is not a good day. But a lot of these people feel abandoned afterwards. And I think, if you can prove them that you're there and you're trying to be their friend and you're supportive of them, and again, I said it earlier, I've gone through the whole thing. I've been sued and I haven't been sued. And so I kind of just say, okay, if this is my mom, what do I want done? And take care of the patient, and all else will fall in there.
So I think those are great. That's great advice from both Alex and Jim. But my thought is, and I get this call frequently, an adverse outcome, my client will call me and say, I'm going to go in and talk to him. What should I say? And so what we do is we try and put together the words that we're going to use, the statements we're going to make. And so that when we go in there, we know exactly what we're going to say. And as Jim said, or Alex, one of you, you don't have to concede that there was substandard care. You can still express your sorrow about what happened or the outcome. But by all means, you want to avoid making some sort of statement that either you or somebody else caused a problem. If you shoot an arrow, it's just going to come right back and get you in the back.
What about if the error was egregious? Let's say I did make a mistake. Let's say I did the wrong level surgery. Is it better for me to just say, I'm sorry, I made a mistake. I did the wrong level surgery. This is how I'm going to fix it. This is what we're going to do. Or do you kind of play, if it's kind of so obvious, do you harm that relationship by not kind of coming forth, or do we still kind of be careful with our words? How would you approach that situation in an egregious error?
Do you want to talk about that, Alex?
I think it really is patient dependent. And I really think that sitting down and thinking about it and formulating how you're going to respond is going to depend on the patient. Every patient's going to be different. So from my perspective, I think it's very important to be very careful what you say, because they will remember exactly what you have to say or what you said in that conference. So I think it depends.
We've got a question from Mohammed Kareem regarding templated consents or templated notes. So in the electronic medical record, people are using smart phrases now, and a lot of notes are looking a lot more alike the last note. How does the legal world regard these templated notes where the verbiage is literally identical? I've discussed the risks and benefits and potential complications, goals of surgery, yada, 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 but it's exactly identical. Do they lose weight because it's the same verbiage every single time?
Absolutely. It looks bad. It looks like what it is, which is just a cut and paste. And it looks like the patient isn't really being cared for. When you have 2 pages of boilerplate cut and paste and the actual exam verbiage is maybe a sentence, it doesn't help you. It really doesn't. So if there's a way around, one of the ways around it is, again, much more verbiage in terms of what you're actually going to put in on the exam portion of the chart or the plan portion of the chart. Much more important. We can live with the boilerplate or the cut and paste if there's a lot of verbiage in the rest of it. And if there's a contradiction, which often happens, okay, patients oriented ×3, and then you get down to the exam and they're not oriented ×1. If there's this discrepancy, some physicians will write at the end of their dictation or their whatever they've typed, to the extent that this deviates from what is otherwise in this chart, this basically controls, or words to that effect. That really helps. That really helps. But you have to be thoughtful about that.
I think we'll have one final question for the evening. It is going to live a little later. This is from Dr. Ramos from University of Chicago. Can the panelists comment on the use of neuromonitoring or not in regard to safety/negligence perception, particularly if there was a neurological complication? Let's start with the clinicians. Jim, you want to start off?
Yeah, so I mean, you either live or die by the sword. I mean, if you're going to use monitoring, you got to listen to it. I mean, there's nothing worse as a guy who's trying to defend someone. The monitoring changed and he said, oh, I'm not going to listen to it, because you're dead. You're dead in the water. I mean, if you use it, that means you believe in it. And then if something changes, you have to do something. So the worst person in the world is, hey, I lost all signals. I did nothing. So if you use it and it's a change, you have to say, I did A, B, C, D, E. I was in the middle of a process. I made the judgment to proceed because of A, B, C, because that's defensible. At least for me, that's defensible. You did something. It's a gray world. You're trying to help the patient. You made an educated guess and you did it. But to do nothing, I just don't think you have a stance. And I think some surgeons like it, but they don't listen to it. And I think that's where you don't want to be. And if you go the other end, you don't use monitoring, I think that's completely defensible. However, I was just talking to a lawyer yesterday about a case, and it's very interesting because I always thought standard of care, you would more have a local standard of care, but his philosophy was, well, if you have a national standard of care, because I think a lot of people are now switching to motor evoked potentials for everything, and some places are into no monitoring and some are into just SSCPs. The problem is, and this goes back to my expert witness, I mean, they always go, well, if I had monitoring, the patient would have woken up normal. And we all know that's not true, but that's the other side of the defense. So that's a long-winded answer. I'm sorry.
That's good. Alex?
Yeah, so it's interesting. So I agree with everything Jim said. So right now,
That's the first time ever.
So Aetna right now is coming back saying, I don't think monitoring should be used for non-spinal cord problems such as an ACDF with just a radiculopathy. So at Jefferson, we use it for all cord level surgeries, MEPs. We use triggered EMGs for placement of instrumentation in the lumbar spine. It's a standard. Everyone uses it. I don't think anyone deviates from it. And we basically, if there's a warning, we stop what we're doing, we respond to it, and we document what we did. You could say, I identify, I checked the pedicle breach. Now, not using it is an interesting thing. I think personally, that one should use it because it has given me information. Even doing an anterior cervical, sometimes you can pick up a palsy because you tape the shoulders down too much. So I wouldn't throw stones if you didn't use it for a ridiculous complaint, but I think it's probably in the patient's best interest to have it for a spinal cord problem in the thoracic and cervical spine. I don't think it's a standard of care issue if you use it or not for a non-spinal cord problem. And insurance companies are now not paying for it. We're fighting right now. I'm a board member of the American Academy of Orthopedic Surgery. I'm fighting 2 major insurers that won't pay for it now for radiculopathy. So the debate is out. We use it in everything, but that doesn't mean it's a standard of care.
Peter, final word on neural monitoring. Any thoughts?
Yeah, I think there is a national standard in malpractice today. There's no local standard. Secondly, I don't think the monitoring is the standard of care, however. I think if you use it, fine. I think it's also accepted by jurors that you decided not to use it. You were trained in a fashion that you didn't use it, and that works fine too. So I think you're right. You either use it or you don't, but I don't think that not using it's a breach or is evidence of a breach in the standard of care.
Great. It's 8:30. I want to thank all the speakers. That was a fantastic discussion, fantastic presentations. Really, I personally learned a lot, so I am thankful. I also want to thank our attendants, our participants tonight. Thank you for sharing your evening with us. We will have the third of our 3 sessions next Tuesday, same time, 8 o'clock East Coast time, 7 o'clock Central time. And thank you all for coming. Good night.
Thank you.
Thanks, Jeff, Michael, and Peter. Nice to meet you.
Nice to meet you all, and thank you.
Thank you, Peter. Thank you, everyone. Bye now.